Welcome to the Senate. There we go. It was really loud. Welcome to the Senate Judiciary Committee. We will start. Who feels led? Chairman Watson, open us up in a word of prayer.
Thank you. Let's go to prayer. Thank you, Lord, for this daylight savings time. I just love it. And thank you, Lord, for looking out over us, and thank you for looking over us and help us be discerning of your ways. In Christ's name I pray. Amen.
Someone should pass a bill that does something about this. You know, I'm still an hour off myself. We have a couple judges join us. I was just telling this first judge that he hasn't been back ever since he won Judge of the Year last year. Judge Burt Guy down in Brunswick Circuit. All right. Welcome back. Anything you want to share with us?
Appreciate the hard work of the legislature.
All right. Appreciate the hard work the legislature says. Good to have you again. Come back. And also Judge John Morse from the Eastern Circuit. Where's Judge Morse? In the back? And where's the Eastern Circuit? Savannah. Okay. Welcome. Good to have you. Come back anytime as well. Anything you have to share with us? Come down to St. Patrick's Day. Fair enough. All right. So we have several bills on the agenda. We have sign-up sheets as always up here. If you want to speak on a bill, please come sign up so I call upon you. We will start at the top of the agenda with House Bill 508. Chairwoman Ballinger, if you want to come on up. We are working off LC 480859. Has passed the House. And the floor is yours.
Thank you, Mr. Chairman. It's a really simple bill. One of the issues, as many of y'all know, I've carried several domestic violence bills over the years, and one of the issues that our domestic violence victims face is service upon the respondent. A temporary protective order, an ex parte temporary protective order, is not enforced until it's actually served upon the respondent. So a lot of times he doesn't even know that he's meant to stay away if she has gone and gotten this ex parte protective order. The idea is to hurry that process up. Time is of the essence. Her safety is at stake. The children's safety is at stake, and we need to hurry this process along. So therefore, we're attempting to put a shot clock in that. The clerk shall forthwith issue a summons and deliver it for service to the respondent within 24 hours of the court's issuance of such order. There are no penalties if it's not followed, but it does, I think, make that statement to the sheriff's office, to the clerk's office, to the judges, that time is of the essence and that we need to get these things filed. We need to get these things in the hand of the respondent so that they can be enforced. And I'll be in, thankfully, thanks to another bill that we have that I passed, most of those temporary protective orders are now on our GCIC so that our cops don't actually have to go, she doesn't actually have to carry around a paper copy. It's actually available to her on GCIC. So, and I'm happy to answer any questions you might have.
So the current process, when an order is issued, the current law says a copy of the order shall be immediately furnished to the petitioner. Who's currently charged with doing that?
Right now it services the area of the sheriff.
And so in your bill, when the clerk shall forthwith issue a summons and deliver it for service, that'll be delivered to the sheriff, is that right? Okay.
Yes. Deliver it for service, and then the sheriff will obviously, is responsible for service of process by the process servers. But so often they get them on Thursday or Friday, and they just kind of put them in a box for the process servers to start again on Monday, whenever really we're trying to say time is of the essence.
Right. Any questions for the author of the bill? Senator Kennedy, almost said Cowser. That's where he always sits. Senator Kennedy.
Thank you, Mr. Chairman, for that distinction. Chairman Ballinger, if you said this, I'm sorry, but so the delivery within 24 hours must be given or delivered upon whom?
The respondent.
Okay.
The respondent in the case of temporary protective orders or stay away orders is the abuser. So the person with whom the domestic violence victim is seeking safety from that person. So we're saying that we're basically saying we would like service within 24 hours. We're kind of saying time is of the essence. However, there is no, nobody goes to jail, nobody's in contempt of court or anything like that if it's not abided by. Well, obviously, we can do that to our sheriff's offices because we know that, sometimes they abscond, they leave town. Sometimes service just is not feasible within that 24 hours, and we know that. But we are trying to basically make the statement the time is of the essence.
Okay, Mr. Chairman, may I follow up? And I support the idea behind this, and it seems very commonsensical and that it should be done. I'm just wondering, are there other statutes that prioritize, if you will, for the Sheriff's Department, those papers that they must serve upon a respondent or a defendant like this?
None that I know of, and I can't think of anything that would be that should be more timely.
Sure,
than these.
and I get that too.
Yeah.
So I guess what you're trying to do is create a model within the service arm of the Sheriff's Department or the county service agent such that this will get priority over the service of other paperwork that have to be served.
Yes.
Okay, great, thank you.
Thank you.
Any other questions for Chairwoman Ballinger? All right, one person, thank you. One person signed up to speak on the bill, Mike Holloman with our Superior Court Clerks Council, right?
That's it. Thank you, sir.
Good afternoon.
Thank you. I am Mike Holloman. I do represent Superior Court Clerks, and I'm here agreeing with Chair Lady Ballinger that this is important to move these things along. When I initially sent this bill out for tracking, I didn't get a lot of response back, and part of that, the clerk of Superior Court in Cherokee County, Ms. Ballinger is a single county circuit, and all of the judges issue all of their orders through e-filing. No problem. Recently, I sent out sort of a push and said, this bill's moving, Did anybody got feedback? Well, I got several, and one email I got today said that I received something this morning in the mail that was signed by the judge on February 28th, postmarked March 3rd, and I got it in 10 days. We think that if you changed one word, or actually strike court's issuance to the filing, and the issue is we can't process for service an order we don't have. We just don't know. We're willing to comply and attempt to comply with the 24-hour time frame, but only upon filing with the clerk. And that's really all. I don't think it substantially impacts the bill. I do apologize to Chairman Ballinger that our people didn't wake up to that issue, but sometimes the clerks I have out in the hinterlands don't follow the legislative process as closely as all of us do. So that's our only comment. We're not against the bill. We think the bill addresses a need, and we simply would like consideration for that small change.
One question I have, if an order is not filed, is it really issued?
Well, there's a bit of semantics there, and I argued with myself about that all day. We had a earlier question about for service to the respondent. I think your question kind of went to that. Is the clerk supposed to do this? I think we thought we wanted to add the word sheriff for service to the sheriff for service, but I think it is, as Chairman Ballinger answered your question, I think it's pretty obvious that the sheriff is responsible for service.
Because I may be wrong, but I'm not sure it makes a difference, because I'm not sure the order would even be effective if it hasn't been filed. And so hopefully judges aren't mailing TPO orders to a clerk that takes days to get there. That sounds
I would hope
concerning in
not.
itself.
I mean, if everybody e-filed, we wouldn't have the problem, or it certainly would mitigate it.
Sure.
But-
Any questions for Mr. Holloman? All right, thank you. No one else signed to speak on the bill. Do you have anything you want to add on his suggestion?
I would say that most pro se litigants who are applying for a temporary protective order are assisted by legal advocates with a domestic violence shelter or someone similar. So I think the likelihood of utilizing the e-filing system is very high among those folks, and I don't think any judges are putting them in the mail for service.
Right. Okay. Any other questions for the author from the committee? What's the pleasure of the committee?
I'll move to pass.
We have a motion to pass by Senator Parent. Do we have a second? Second by Senator Rett. Any discussion? Any amendments? All right, all those in favor of the underlying motion to pass, please raise your hand. It is unanimous. And
Thank you, Mr. Chairman.
who will be carrying the bill in the Senate?
Senator Parent will be carrying it for me.
Did you know? All right. Thank you.
Like 5 minutes ago.
Yeah, that's more warning than you get a lot of times. So, all right, thank you. All right, we're going to go out of that order with one bill here at the end. House Bill 166, Representative Mathiak. Chairwoman Mathiak. Give us a second because I went out of order for everybody to get the bill. All right, I show LC 472067 has passed the House. Is that what you have?
Yes, sir.
All right, the floor is yours.
Okay, thank you, sir. This truly is a small bill. It was brought to me by my magistrate judge in Spalding County. She still uses a constable to deliver her documents. And the law as it reads today is the constable needed to reside within the county, not the Griffin Judicial Circuit. So she asked me to carry this and see if we couldn't move that along so that she could hire somebody actually from, I believe, Upson County or Pike County, one of the two. So what we did is we rewrote it and put in at least 21, citizen of the United States, registered voter, and obtained high school education or GED. And that is the long and the short of this bill.
So Spalding County is the only county that will be affected by this?
You know what? I was afraid you were going to ask me that. I'm not sure. I'm not sure because I think most counties use their sheriff's department. She just happens to still use a constable. And there may be other smaller counties that use constables.
All right, any questions for the author from the committee? You have a question from Senator Hatchett.
Thank you, Mr. Chairman. No, my question is, I see the qualification that you have. One is to be a citizen of the United States. Is their residency or which state they live in, is that not taken into account?
Well, that was the whole issue, was to be able to have them within the jurisdiction. Specifically the Griffin Judicial, but this would be for the whole state, so it would be for that jurisdiction.
Okay.
So you're saying because this is for Spalding County, but you're in the Griffin Judicial Circuit, so she could get
Yes.
somebody in Pike County?
Right.
Okay.
Right.
But they still have to be a citizen of the state of Georgia?
Yes.
But that's not listed as one of the qualifications, right?
Be registered to vote. Does that count?
Yes. Well, yeah, to be registered to vote, but I believe that it's in the OCGA law previous. This was just added.
Okay.
This language was just added.
Okay, thanks.
Here are questions from the committee. No one has signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass from Senator Watson. Do we have a second? A second from Senator Jones. Any discussion? All those in favor of the motion, please raise your hand. You are unanimous. And am I carrying the bill?
I will hope you
The
will.
ex officio senator for Spalding County?
Yes.
Okay, all right. Thank you.
Thank you, ladies and gentlemen.
All right, next, going back to the agenda, House Bill 91, Representative Wade. Floor Leader Wade, right?
I'll answer the most.
Leader Wade.
Just honored to be here. Thank you, Chairman and Senators. I appreciate your time.
Give us the LC number, 442171, is that right?
LC 442171, that is affirmative. And if you need to clarify whether or not God has a sense of humor, I agree with the Senator. Just look at him allowing us to create daylight savings time. So
That's right.
I can tell you at our house, it's been an interesting Sunday and Monday with our two youngins.
Same at mine.
you know the drill. So I'm excited to get home tonight. This bill is actually a bill that we passed last session on both sides. We went through a process working with all the folks in the probate world, as well as credit unions and banks and bankings, is referenced in Section 2. It did pass unanimously. We ran out of time on sine die. There was a little bit of a language change at the last minute to make sure that we were not inadvertently excluding credit unions, but happy to go over the bill again, just so those that were not here are a part of it. What this is going to do in Section 1, it's just going to require that if you're named a beneficiary in a will, not a specific heir. So an example would be if your mother or father, your friend, whoever that you're representing as an executor, if they wanted to name a church or a nonprofit or a hospital or anything like that in the heir, that entity, who's a non-person, would receive notice just like an actual person would, an heir would. We had a situation back in my district in which someone made a decision to give notice and provide the directives from a last will and testament to all the heirs that were named, but did not actually meet the requirement to notify or to actually remit the wishes of that person's to a church, and also to St. Jude with a large sum of money. And that person honestly almost got away with it. I know that's a rare case, and I know that that's not something that is a huge risk, but I would argue that if we don't allow folks that are named that are beneficiaries not to receive notification, it just opens up the door for, someone that might normally comply might take a chance and see it as a window. The second section of the bill is cleanup language that the Georgia Bankers Association, the credit unions, and the CBA all agreed with. This is just the Section B, that an investment management account would, or an advisory account would also have the same beneficiary notification, so that it would not have to go through probate. So if you've got, just like your CD or a checking account, all of those securities would be able to be automatically passed to the other named person on that account. And so that is what the bill does. I'm happy to answer any questions, and I appreciate favorable consideration.
All right, any questions for the author? All right. No one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass. And the other floor leader, Hatchett, is there a second? Is this a governor's bill? You don't know.
This is not a governor's
Okay.
bill, actually. But the governor's office was very comfortable with me carrying the bill again, since I carried it last time. And then Senator Gooch carried it last time, but I know he's in leadership now. I don't know how many bills he's carrying. So I'd continue the process.
We have even though it's not a governor's, it's a Gooch bill. You have a second?
Yeah, I almost hesitated, y'all.
All right, any discussion? All those in favor of the motion, please say aye. Aye. Any opposed? All right, it is unanimous. And who's going to carry it? Senator Hatchett?
So I'm open to the chairman's recommendation. If Senator Hatchett be willing to carry it, I'd be honored for him to do so.
He said he'd be happy to do it.
All right.
All right.
Thank you, Chairman. Thank you, colleagues. Appreciate y'all.
Appreciate you. All right, Senator Reeves, House Bill 182. Excuse me, Senator. Representative Reeves.
Senator on there.
Does it on there?
On the Civic Research one.
That's not where I got the mistake from, but I'll go with that. How long have you been in the House?
Since January the 9th.
And you've got how many bills in the committee?
I'm helping out my chairman.
Yeah, but how many bills did you pass in the House this year?
Got 5 passed.
Is that a record for a freshman?
No, it's not. No, it's
you
not.
checked to see. You were trying to break a record?
My chairman told me how many he got passed, and it's several more.
And how many was that?
I think 7 or 8.
Came up a little bit short. How many of those passed both chambers?
Not sure. I'll check that out.
Okay, you might still can catch them. All right, House Bill 182. And this is a substitute. We were working off LC 442344S. And I know there was a little bit added in a substitute, so if you'll separately address that, of course, address your line bill too.
Thank you, Chairman Strickland, members of the Judiciary Committee. House Bill 182 is a commercial real estate ownership and lending and title insurance bill. Section 1 of the bill addresses a court decision that came out about the time that the session last year ended, the Scarver case. And I have Matt Mashburn with the State Bar Real Property section here with me. They responded to that court decision, which put in jeopardy scriveners' affidavits or deeds to correct errors regarding acknowledged deeds. The 11th Circuit Court decision, the Scarver case, said that acknowledged deeds, you cannot correct them after the fact due to some 2015 legislation, the language in there. And that definitely was not intended. For decades or centuries, Georgia law has treated attested deeds similarly to acknowledged deeds. And an attested deed is the traditional closing where everybody's there, the witness, the notary, the second witness, the signer. Whereas an acknowledged deed, that's when the deed is signed and brought into the closing and everybody verifies that that person signed it. Acknowledged deeds are done more in more states, whereas Georgia does attested deeds, but Georgia law has always treated them on par with each other. But the 11th Circuit case said that if you have an acknowledged deed, it doesn't relate back to the closing if you try to correct a clerical error. That alarmed a lot of lenders and property owners, title insurance companies. So Mr. Mashburn and the real property law section of the bar, as well as the state bar, spent time since last session when that court decision came out to correct that error. So that's section 1 of the bill that puts attested deeds and acknowledged deeds on par to make sure that those security interests, particularly purchase money security interests, are safe and secure if there is a clerical error that needs to be corrected. And section 2 of the bill is a follow-up actually from Chairman Gunter's bill last year relating to timeshares that you might recall. There are 18 current timeshares in Georgia, and last year you did some legislation that helped the legal landscape regarding the existing timeshares. After that bill came along, some national timeshare companies came and brought an idea to put Georgia more on par with national timeshare companies when it comes to ownership and lending and title insurance and legal procedures. And so the 18 existing timeshare companies and then the national companies spent since January the 9th crafting Section 2 and following of the bill, which would promote more timeshare investment and lending and title insurance in Georgia. So this bill addresses a number of issues and makes Georgia attractive from a commercial real estate ownership and lending and title insurance perspective. And I yield for any questions.
All right, any questions for Representative Reeves? Senator Cowser, is that yours? Senator Cowser.
Chairman. So this, all your timeshare portion did not pass the House. That's something new you're
Correct.
adding?
It passed the Judiciary Committee, but it got passed later than Section 1 pertaining to the deeds, and so it was ready to go and was one of those bills didn't make it across. We talked to all of the parties involved, and they were okay with combining them. They had looked at both bills and were comfortable advocating it back if the Senate passes it.
Apparently the Speaker didn't think it was serious enough
Well,
or significant enough to put it on your floor.
The Sections 2 and following, because it got passed so late, it was too complicated to absorb on the days leading up to crossover. It got passed the week before crossover.
Follow up. We had, or I had some difficulty with the bill last year. My concern was that a timeshare owner was being foreclosed on without adequate notice or due process. Can you explain to me the difference in these sections and
Sure.
what was in the legislation last year?
Absolutely. Section 2 and following of House Bill 182 leaves intact everything that was done last year relating to the smaller 18 existing timeshares. However, this bill creates a more detailed set of statutes for the larger timeshare companies that have loans and title insurance and are more national. It does have more detailed, lawyer-oriented notice, advertising, more traditional commercial real estate procedures that the smaller timeshare companies last year were not comfortable with. This creates a second set of more complex procedures for larger projects. Wyndham Hotel, Margaritaville, people like that who are doing timeshares, this would let them be comfortable with Georgia law. It gives a set of statutes. South Carolina's got over 100 timeshares. Florida has several hundred. They're number 1 and 3 in the country, respectively, and this would allow national companies to have more comfort, a comfort level with doing business in Georgia under this set of statutes.
So my real interest is the person that is getting foreclosed on.
they would.
What changes in their life? I'm worried about the consumer, not the
Sure.
national companies selling
Absolutely.
timeshares.
Section 2 and following of House Bill 182 gives a detailed set of notice and due process procedures that's more traditional in Georgia foreclosure law, with the advertisement, the letter, things like that. You're gonna have a lawyer involved, and it's gonna be more extensive. The bill last year was more conducive to kind of a smaller mom and pop local timeshare. This bill this year has a lot of rights and notice and procedures.
So you get to choose one route or the other?
Correct, exactly. When the property's being developed and the owners association is being set up, they could go with the simple one or this one, which is more complex and robust. And everybody who's looked at it believes that by enacting Section 2 and following, you're going to have more of the national timeshare companies that come in and invest in Georgia, bring tourism here.
Any other questions from the committee? All right, nobody else. Do you want to say anything else? Or?
The sponsor,
All right.
sponsor did a great job.
All right. Nobody else signed up to speak on Senator Parent?
Thank you so much. Thank you, Representative. You may have already said this, but was this the new sections 2 and 3? Was this your bill as well, or no?
Yes.
Okay.
Yes. Chairman Gunter did the timeshare bill last year. When these national companies approached, he asked me to work on it this year, and 5 of those 18 existing timeshares are in his area in North Georgia. And so Vernon Lee, who is here, represented those some of those 18 existing timeshares. Chairman Gunter looked it over, and they made sure that this bill was separate from what was done last year and kept that work intact and added it on.
Thank you. Quick follow-up. What was do you recall the bill number in the House?
The one from last year.
Didn't you say one got filed?
The one in the House it was House Bill.
All their bill numbers.
Yes.
You have so
All
many,
right,
you don't
here we
even
go.
know.
292. 292. House Bill 292. The state bar, day one, they were ready on the acknowledged deed fix. That got passed pretty early. 292. The smaller timeshares and the bigger ones, and Chairman Gunter and everybody looked it over for a few weeks. It got past the committee and onto the rules calendar a little bit too late.
Thank you.
Any other questions from the committee? All right, what's the pleasure of the committee? We have motion to pass by committee substitute by Senator Rhett. Is there a second?
Second.
Second from Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. All right, we have 1, 2, 3, 7. All opposed? 1. No, that's fair. Is Senator Calvert carrying the bill?
Mr. Chairman,
Make him on it. Make him really on it.
Mr. Chairman, I'd be honored if you would.
I'm going to carry. Okay, let's see if I can get Senator Calvert on. Might be tough. All right. Is that going to count as 2 bills for you now? Or are you trying to get your numbers up, putting 2 together? All right. You have the next one too?
I do.
All right.
Thanks, Mr. Mashburn.
All right. House Bill 444. I believe we've seen this before as well,
Yes.
haven't we? Let's make sure we got the right LC.
49-1253.
All right, 49-1253. Okay.
All right, Chairman Strickland and members of the committee, if this bill looks familiar, it's because it is. This is the Senate version of the Liz Pendon's bill from last year. There had been this is another commercial real estate clean title bill. There had been some problems with Liz Pendon's, and of course Liz Pendon's a Latin phrase that means a lawsuit's pending. This bill codifies some dozens and dozens of cases in Georgia law and defines, when it's appropriate to file a Liz Pendon's, which is a filing in the real estate records. It also sets some procedures, formal procedures about the filing of the Liz Pendon's. It also gives some due process and some clarity and some definition for judges to analyze Liz Pendens to decide what to do with it. It gives sort of a menu or checklist for judges, either find that the Liz Pendens is improper and remove it at an early stage of the proceeding, find that the Liz Pendens is proper but have a bond to be posted because of some high stakes in the case, find that the Liz Pendens is proper and leave it intact, which that happens more times than not just by default, or the court can return to the issue at a later date. So this basically calls for some scrutiny on the Liz Pendens. I think the momentum has been in cases just to leave it on there until the end of the case, which clouds title. That could affect loans and title insurance and the ability to sell the property even if the Liz Pendens is invalid. And also it places a duty on the party that files the Liz Pendens to take it off once the case is over with. If a Liz Pendens is proper, to give notice of a lawsuit. Once that lawsuit and all appeals are concluded, it's time to clear title on that Liz Pendens. So this is the Senate version from last year, and would be honored if you pass it this time. It did pass House and Senate. There were some minor changes, and the governor had some important business there the last hour or two of the session that sort of kicked this off the list, and so we're ready to get it done quicker this time. So yield for questions.
Are there any questions for Representative Reeves? Senator Kennedy.
Thank you, Mr. Chairman. Representative Reeves, you said this is just like the Senate bill that passed. Is this exactly the same bill as what we passed?
We gave Legislative Council the as passed in the Senate, and they said they would, clean up any clerical errors, but that is what, I'm not aware of any changes to what you passed last year.
Okay, so you're telling us substantively it is exactly the same as the bill that the Senate passed?
Substantively, yes, definitely substantively.
Okay.
And I'm not aware of any changes they made. They said they needed to look at it for any clerical, I think the Senate version, they said they needed to, because of when it was passed, they needed to check it for editorial issues, but I'm not aware of anything they did from a clerical perspective, and substantively, it's my understanding it's the same.
Okay, and then if you would, I guess looking at lines 37, walk us through how you think the bond process would work. I see that it requires to pay or post in the registry of the court of bond and the amount determined by the court.
Sure.
Is that the only guardrail that's provided to determine the amount of the bond or the type of bond or any other terms that would go along with a bond that would be required?
I believe so. It would be similar to a supersedious bond, which the courts look at more frequently, but this bill kept it a little bit more general. But from a practical perspective, the same companies that post supersedious bonds would be the ones who would post it in this case. It's left a little bit more general than supersedious bonds, but the judge, right now there are no due process or checks and balances on Liz Pendens. This at least gives the judge an idea to require a bond.
Okay, thank you.
Thank you.
Any other questions from the committee? Nobody wanted to speak today. Nobody signed up to speak on this bill. What's the pleasure of the committee? We have a motion to pass by Senator Hodges. Do we have a second? Second by Senator Jones. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank you.
And am I carrying this one?
I'd be honored, Mr. Chairman. Thank you.
Thank you. All right. Chairman Leverett, you finally got done with that committee?
I did, yes, sir.
How many Senate bills did y'all pass out today?
All of them.
All of them. Most importantly, mine passed out, didn't
We
it?
did, Mr.
That's right.
Chairman. I hope it wasn't too obsequious for me to call you first.
Oh, no. I'm sorry I called you last over here.
That's all right.
We have House Bill 80, working off substitute, LC 491420S. The floor is yours.
Thank you, Mr. Chairman and members of the committee. It's a pleasure to be back here yet again. I think I'm going to hopefully qualify for frequent flyer miles this year, or maybe a bulk discount. Do I get like, it's like I have to get my card stamped so I get a free bill, like the 10th one or something?
I think this is the last time you're coming, isn't it?
I hope not. I hope it's not. The bill today is House Bill 80. This is essentially, with some changes, adopting the Uniform Unsworn Declarations Act. We do have some changes to some of the uniform provisions, but what this does is it basically allows an unsworn declaration, which I'll describe in a minute, to be the equivalent of an affidavit in a civil suit under certain circumstances. So the unsworn declaration to me is a little broad or general. We're really talking about a written statement that is not notarized but is sworn to, in the sense that it's given under penalty of perjury. So it has the same effect as a sworn statement. You just don't have to actually go through the process of appearing before a notary when you sign the statement. So it's the same, it's the same impact. You still get in trouble if you aren't truthful in it, but you don't have to go find a notary. This is the bill was the genesis of the bill was the Atlanta International Arbitration Society, and Rebecca Kolb, the president-elect, is here today if you wish to hear from her, because this obviously in their business of international arbitration can be a big deal. Overseas, getting a sworn statement is extremely difficult. The only notarial equivalent for a sworn statement is a consul or vice consul. So if you are making a sworn statement overseas that you're submitting to be heard here in a case in Georgia, you've got to make an appointment with a consul or a vice consul, which of course is at a consulate, and those aren't exactly spread out in every county seat, so to speak. You may have to drive several hours to get there. Once you get there, the consul may be busy and may not be able to keep the appointment. My understanding is it also can be difficult to get these appointments. It sometimes takes months to get the appointment, so you may show up and then have to go back and come back for a few months. I actually had someone in Mexico try to do this, and it was an extremely lengthy process. So the unsworn declaration is much, much simpler logistically. There is a set form that's in the bill that the signature line must contain, so the person knows that they're signing under penalty of perjury. And if it's in that proper form, then it can have the same effect as a sworn statement. It does have to be in that particular form, however, so the person signing knows what they're doing. But it's so much easier logistically. And there is also precedent for this. This isn't new. Federal courts have been allowing unsworn declarations for over 50 years. Approximately 32 other states allow it in some form or another, either through the Uniform Foreign Declarations Act, the Uniform Unsworn Declarations Act, or some non-uniform law of their own which allows this. This also, I think, would be of use to the International Arbitration Society, is promoting Georgia and Atlanta as an international arbitration hub. We've done a few things. The Mediation Act, the Uniform Mediation Act, we adopted. So we're trying to promote that. So it's kind of an economic development bill also, in a sense. It does not impact wills or deeds or oaths that have to be sworn before specific officers. This is just basically a substitute for an affidavit in a civil proceeding. The changes we made here that are different from the Uniform Act is the Uniform Act applies to a written declaration signed anywhere. We initially started with that, but it didn't make it out of the House that way, so it's limited to a declaration that's signed basically overseas, somewhere outside the United States and its states and possessions, and that sort of thing. And it only applies in a civil case. It can't be used in criminal cases as well. So we believe this would be of great use to litigants in civil cases here in Georgia. Certainly for international arbitrations, it's going to greatly simplify that process. The State Bar does support the bill. The Board of Governors has approved it. And we would appreciate your favorable recommendation on the bill today.
And if you can briefly just highlight the changes from this version, the substitute, versus what was passed in the House.
Yes, sir. Yes, sir. So it was pointed out to us that if you're going to limit its application to statements which are made overseas. In other words, if the validity of the declaration depends on where you are when you sign, then the statement right above the signature ought to also make an affirmative representation as to your location. So if you look on page 3 of the bill, lines 54 through 56, there is language there where the Uniform Act, the statement as I declare under penalty of perjury under the law of Georgia that the foregoing is true and correct, period. So we've added, after the word correct and the comma on line 54, the remainder of that paragraph, and that I'm physically located outside the geographic boundaries of the United States, Puerto Rico, the United States Virgin Islands, and any territory or insular possession subject to this jurisdiction of the United States. Similarly, we also went back and made the language in paragraphs 31 through 30, in lines 31 through 34 on page 2 consistent with that statement, so that the requirements of the law as to location matched with the affirmative statement the declarant was making when they signed. So those are the only 2 changes we made, Mr. Chairman. We did make some changes from the original bill, but as far as what was passed on the floor, that's the only change we have added.
All right. Any questions for Representative Leverett? Senator Hatchett.
Thank you, Mr. Chairman. My friend who is a chairman of appropriations would get on to me if I didn't ask this, but will this have any effect on remote notary?
This does not touch that, no, sir.
Not yet.
Okay. Just making sure.
It has nothing to do with real estate, and deeds are expressly excluded.
I didn't think so, but I had to ask
Self-proving
for
affidavits are
Chairman Tiller
excluded.
there.
Yes. No, but a good point. I'm glad you.
He wanted to change the name of the bill because of that very reason. He was coming over to the Senate. We discussed that, but because it kind of sounds similar. Who else pushes? Senator Cowser.
Thank you, Mr. Chairman. So is this dealing with like criminal laws for perjury, that you're now allowing it to be perjury if somebody gives an unsworn statement that's false?
If it's in the form required by the bill, it has to be a declaration that's clearly intended to be used for evidence. The bill sets out the form of the declaration, which I was just quoting from on lines 53 through 56. Right above the signature, it has to contain a statement that you understand you're giving it under penalty of perjury. But yes, you could make a statement that was technically not sworn, I like to say not notarized, because you are making it with the effect, the same effect as a notarized statement, which is that it is, you're committing perjury if you lie in it.
Okay.
Any other questions from the committee? All right, no one else signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Watson. We have a second. Second is your motion by committee substitute. We have a motion to pass by committee substitute Senator Watson, a second by Senator Kennedy. Any discussion? All those in favor of the motion, please say aye. Aye. Any opposed? It is unanimous.
Thank you.
And
thank you, members of the committee.
Who will be carrying this exciting piece of legislation?
Well, again, understanding that y'all are offering bulk discounts, I understand Senator Kennedy Pro Tem had agreed to carry this.
He likes carrying stuff like this.
Yeah.
So. All right.
It's, as we say, it's our wheelhouse.
That's right.
The boring stuff. Yeah.
All right. Thank you.
very much.
We'll see you again soon, hopefully.
Yes, hope so.
All right. That's all the business we have. Somewhere Jesse Stone, if he knows about this, he wouldn't be very happy. We're adjourned.